We're live. I think we're live. We are live. 5, 6, 7 seconds. We're live. All right. How's everybody doing tonight? This is last live stream we did was about a week ago, I think, with Robert Barnes about the Arbery case. It was actually, let me just see when it was. 5 days ago was our last stream. All right. What's to say? We are now 3 months into the temporary lockdown to flatten the curve. And we are now 3 months into it with no end in sight. Apparently the borders, for anybody who's paying attention, between Canada and the US are closed until January. Hopefully not. June 21st. So yeah, no. Let's see. We've got a lot of people in the house. I'm going to bring them in. I'm going to bring up some names, say hello to people. I'm not reading your comments before I bring up the names, so don't yell at me if I bring up an inappropriate comment. AR-15s have no hunting purpose at all. Well, okay, this is obviously a conversation that I am not currently involved in relating to my Justin Trudeau firearm ban, which is an interesting subject. Fry should try a tie-in to Riccietta pre-show crowd. Get Nick's gang in for a drink. Yeah, I did a live stream with Nick a year ago, I guess, give or take. He starts too late and he ends too late, and I start like 9:30 is already late. The kids are still not asleep. I hear them upstairs running around. If Nick would bump it up an hour and then we do it 1 hour and then he goes into his midnight late thing, I could do it. But otherwise... Okay, let's see what I can bring in here that's not going to get this stream shut down within the first 5 seconds. Okay, we got Golden Mongoose. Yes, that's an innocuous comment. Golden Mongoose, nice to see you here. A triple wow factor, wish I could 3 times like. Becky Ryan, nice to see you. Jose Viguera's in the house. Son of a gun, I don't know what that says. It better not be bad. All right. Let's see. We got Melvin Hawkins. Is that after taxes? All right, everyone. While everyone trickles in, and share the link around because these things don't always go get notified properly. New member. We're starting off well tonight. Morgan Gilders became a YouTube member. Morgan, you will get 1 to 2 hour sneak peeks of videos before they go public, so you can get in a comment before it happens. What's up, Fry guys? Greeting from Long Island, Moore's Worldwide. We got Michael F. That's not going to get this stream shut down. Stream starts lagging. Okay, hopefully while everyone just trickles in, I'll avoid overtly controversial messages, whatever. Did I hear the new developments in the Arbery case? I have not, but we are inevitably probably going to talk about it. But Jeffrey, do let me know what they are. Do I think I know what they were? Mrs. Massachusetts, you have renewed my faith in French Canadians. You do great work. Not to shatter your faith in French Canadians, I happen to be an English Quebecer. I am one of the 15% allophones in the province. That being said, I appreciate it. I love Quebec. I'm not leaving. I'm one of 5 siblings of my siblings that have stayed in Quebec because I do love it here. Oh, I feel totally at home here with so many who dislike Trudeau. Look at this. We got 2 new members. Nick Mary became a YouTube member, and my YouTube became a member. Amazing. Now, before I bring in, Nate is looking for a camera that works because his camera was having problems. Kurt, I see here, is, hold on one second, 390 watching, 75 likes. And I know 3 of those likes come from me, my wife, and my daughter. They all have YouTube channels. All right. I'm going to bring it. Yes. Nate has got a camera. I'm going to bring in Kurt first because Kurt and I have to discuss Gentleman Jack. You know what? This can get something shut down also. So I'm drinking Gentleman Jack tonight. Never liked it. Never knew what it was. The only reason I got it was because when I go into our liquor store, I hold my breath, grab whatever I can find that's right off the shelves, go to the cash, and get out within one breath because I'm crazy in general. I didn't know Gentleman Jack was made by Jack Daniels. And it's not terrible. Mike D, thank you very much for the super chat. And we got Biggles Mets, another member. Now, I started telling Kurt about Gentleman Jack, and he likes it, and started telling me a little bit about his affiliation with Jack Daniels?
Yes. So I am what they call an esquire. I dug out my membership card from my bona fides. There's my Tennessee Squire membership card for Jack Daniels. I am the proud owner of 1 square inch of land at Jack Daniels Distillery. It is plot number H67100. So yes, I'm the proud owner of 1 square inch of Jack Daniels land as a quasi ambassador of their brand. And I've been down to the distillery. I'm a fan of the stuff. Gentleman Jack is made by Jack Daniels. Jack Daniels, what makes it a Tennessee whiskey, or at least the way that they do it, is what makes Tennessee whiskey as opposed to bourbon, is it goes through this charcoal mellowing process that's not required by bourbon. So technically, all Tennessee whiskey is bourbon. But what makes it Tennessee whiskey is it goes through an extra step that bourbon isn't required to do, which is charcoal mellowing. So at Jack Daniels, they have these 10-foot tall vats that they fill with charcoal that they make themselves. They burn the wood and they make the charcoal, and they fill these vats 10-foot tall, and they put the Jack Daniels on top of the vats. And it takes time to gravity feed through the 10 feet worth of charcoal. And then when you get to the end of it, that's part of what makes Jack Daniels Jack Daniels. And then what makes Gentleman Jack is, I don't think they go through the 10 feet again. I think it's like another 3.5 foot that they go through. So the phrase double mellow is a little bit misleading because it's not twice as much. But I do prefer it over Jack Daniels because it does have a much more mellow profile. So there's more than you ever want to know about Jack Daniels.
Well, I like the idea of owning a 1-inch plot, because whenever I hear plot, I don't think of ownership of land. I think of where you get buried. So like if I own a 1-inch plot on Jack Daniels, maybe if I passed, I would get cremated and they would put me. Can they do that? Would you think they would do that? Like spread your ashes on the plot?
Oh, hell yes. I have no doubt in my mind that if you want to be cremated, have your ashes spread at Jack Daniels, they'd be happy to do it. Yes.
All right, now let's see Nate laughing because I can see Nate's face. I'm going to bring him to the stream now, and then we will officially be the 3 lawmen of the My Sharona Cyrus.
Yeah, but don't. I have my membership card, so don't call me a liar. I got my membership card.
First of all, we've learned a lot. Gentleman Jack is not bad. It is in fact mellow. It's mellow. Oh, Nate, this camera won't do. You're very soft around the edges. We can't do this.
Well, from no camera to some cameras, I'm happy to be here.
Well, Nate is naturally soft around the edges. That's probably like Nate.
Well, just so everybody knows, before Nate was here, it was Nate's avatar, and when the avatar talks on StreamYard, it pulsates. And I don't like the way an avatar goes. Wah, wah. It's like very much like Hal from whatever that movie was, 2001: A Space Odyssey.
No, you aged yourself with that one, 2001: A Space Odyssey. When did that movie come out? It came out in the 80s, right?
I thought it came out in 2001.
Hey
Siri, when did 2001: A Space Odyssey come out?
2001: A Space Odyssey was released April 3rd, 1968.
Woo!
68.
Wow.
Dude, that's old. 1968. We got Sam H09 said 1970. Look at this. I thought it came out when I was born, like not around the early 80s.
But I, in addition to being affiliated with Jack Daniels, I should point out that I'm affiliated with other brands too. I'm also an ambassador for Maker's Mark, and I could tell that story too. When I turned 21, I bought a barrel of, or piece of it. I bought a piece of a barrel of Maker's Mark that didn't yet exist because they were making it. So I bought it in advance. So they were making it for me. So fast forward, 12 years later or something, I go down there to get my bottles of Makers that they made for me when I bought it when I was 21. I still have them in my cupboard, so I could break those out too.
Unopened or opened?
They're unopened.
Wow.
I have 2 bottles that are unopened. Yeah, from that batch.
Wow.
I'm looking at people who are now saying, a lot of people, which is aging our subscriber base. A lot of people knew when it came out. They might not have been born then. They just might know more about movies than we did. But
I also did the full Kentucky Bourbon Trail. Went down there and did the whole tour of all the ones that are in there. I got a T-shirt for it. That was my grand prize for filling out the passport. So I've been to all the major distilleries. Been to Wild Turkey. been to Woodford Reserve, been to Jack Daniels, been to Maker's Mark, and so forth and so on. If you're ever down there in Bardstown, Kentucky, recommend it. It's a nice trip.
When the borders open up, my travel is probably going to be limited to North America. But Kurt, when the borders open up, we did Scotland with my now deceased father-in-law 12 or 13 years ago. We did Lefroy. We went to Brookladdy. We did Lagavulin. We did. We went to Skye and we did Talisker. We went to the Isle of Jura and we saw the Jura distillery. Amazing, best place on earth. And by the way, just to answer this, my name is David. I'm actually Viva is a totally created name, which a lot of people said I should have changed my channel name because people would have thought Viva was like short for Vivian or something. Borders are not opening. Well, sorry, that was the wrong one. Borders are not opening. We'll see. Another month at least, which is madness. All right. So first things first, everybody knows Kurt Uncivil Law. Everybody knows him. If you don't know him, check him out. He does, we all do law with different styles and different themes. Kurt's got a channel, Uncivil Law, also known as Blackleaf.
Yes.
Okay, we're gonna open this up with one parenthesis. So a video I did about Justin Trudeau banning assault style rifles. We could kick it off with this because Kurt said I was going to take flack in my video for my referring to these weapons as assault style or military. What did you say, Kurt? You said I was going to get in trouble for
it wasn't sufficiently clear in your video, in my opinion, that when you were describing them as assault weapons or military weapons, that you were using Trudeau's language as opposed to your language. Because if you call those firearms assault weapons or military weapons, and you're not putting massive air quotes around the whole thing, people are going to get very upset because these things have actual technical definitions that no one respects. And so I thought that your video did not make it sufficiently clear that you were using it quoting Trudeau rather than expressing your own view. So I was like, oh, that might be a problem.
Well, so this is the funny thing. First of all, I have no view because my understanding is of weaponry is very limited. And the hilarious thing is I was going to use the Chris Farley. You remember on Saturday Night Live when he was doing the air quotes and he started flying through the crowd? I was going to use it, but then I didn't want to get a copy claim from NBC or whoever it is that owns it because they're notoriously aggressive. So I didn't use it. But yeah, no, I was using Trudeau's terminology because that was the terminology. I put it in quotes in the title. And yeah, I mean, I even said in the video, in Canada, there is no legal definition for assault style rifles. And people are rightly pointing out, there's no military grade either because they're what's sold for commercial purposes are not military grade assault style rifles. They're, like I said, in Canada, like they're already limited in terms of the magazine capacity or the legal capacity. And they are what they are, but it's
but here
I did get some comments.
Well, one thing quickly here we have like for instance, like I'm not sure if it's the ATF or which agency, they'll define that ambiguous term. Like they'll define what assault weapons are blah 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 blah, and it'll go through an administrative agency. So I'm not sure if you guys have like an equal thing to that, but because the way I was understanding, the law is giving someone some power to enforce this. So they're going to have to define what that term is.
So I don't know that we have that here. I know that there's some disagreement now because there's no legal definition for assault style. A lot of people are saying something, and people who are watching can comment now and let me know. A lot of people are saying 12 gauges duck hunting rifles are getting caught up in this ban because it banned rifles with a muzzle of greater than 20 millimeters, something along those lines. And people were showing measurements of duck hunting rifles with the choke, and these are terminology that I don't know, that they were 20.2 millimeters, and they're saying like, look at this, duck hunting shotguns are now caught up in this ban. Other people are showing these rifles are like objectively hunting rifles with minimal capacity of magazine capacity that are caught up in this. So we have from what I understand, we have no official definition of assault style rifles, and it's unclear what's going to be caught up in this. And it's crazy. Like, the government's still not even sitting to have a debate to see what is going to be included in it. But we'll see what happens.
Yeah, but typically, at least in U.S. law, when we're talking about assault weapons, to use that term properly, one of the things that you have to have is select fire, which means that you have to be able to change the firing mechanism from one fire per trigger pull to something else other than that, such as 3 or fully automatic. So since AR-15s do not have select fire capability. They are not assault firearms within the meaning of the definition. Now, when they had the assault weapons ban, because that was when we're talking about an assault firearm. When they had the assault weapons ban, this is how they love to change terminology and use it different ways. Then when they talk about assault weapons, it's like, oh, now we can define it to be anything we want. Okay, great. So assault weapons were firearms that had, among other things, had to have 2 or more of prohibited characteristics. So it had to have a thumb grip, or it had to have a bayonet lug, or it had to have a grenade lug, or it had to have a muzzle brake, or it had to have a barrel shroud, or it had to have one of these other things that mostly are aesthetic. But if you had 2 or more of these things, then somehow it became a big scary gun, even though without those things, it fired exactly the same round at exactly the same velocity. So the firearm was no more deadly, but it looks scary. And that was enough, I guess, or something.
Well, and that's my understanding as well, is that in Canada, with rifles, with long arms, by law, they're restricted to 5-round magazines. With handguns or with certain automatic, I don't even want to say semi-automatic pistols, you can have a 10-round magazine. And one issue was that there was someone told me this, and I don't know the last thing about it, but you could swap the magazine for a pistol that had 10 rounds with a rifle that had 5 rounds, and then in theory convert that rifle into a 10-round firing weapon. But I mean, we already had strict laws, and they were already extremely restricted. Restrictive in the sense that you had to take the class, you have to do 2 days, you have to register them, you have to buy them. You're on a registry, and no discussion, no nothing. Overnight, those very weapons, which are already extremely restricted, just went from non-restricted to prohibited, which is mind blowing.
That seems like a slight difference to my ear.
Oh no,
non-restricted to prohibited. That seems almost a strange juxtaposition.
Oh no, it's objective, and there's 50, and then it's what weapons are on that list. This all had a segue. Let me just get these 2 super chats. David, did you see the new Freedom Tunes video? It's about Canada. It's hilarious. I haven't, but it's on my list right now.
I have saw it, and it was a lot of fun.
It was fun. Apparently, the band also included a coffee company. Thank you, Maddox. This was where I nearly got into trouble for my fake news Friday, where I'd had to feature myself. So I read this issue, and I read also that it banned an airsoft rifle because they have the exact same names. So it was a black rifle company, and it was BRC 15. And I actually did like an unedited sort of like, I'm Googling it. This is the weapon that I have on the list. It was item 70 something or whatever, or 1700. It's under alphabetical order, so you can actually go check it. And then I Googled it, and yeah, sure enough, Black Rifle Company is a coffee company. And so I was like, oh my goodness, look at this. In their haste to pass this legislation by order in council while the government is not sitting during a pandemic and the government officials are at home, they blacklisted a black coffee. What was it called? Black Rifle Coffee. Reality is apparently the rifle was some very obscure rifle. They had one line of rifle that was sold 20 years ago, and it's a legit rifle that they did ban. The other one, which is the airsoft rifle itself, was named after a legit rifle that they legitimately banned. So it's on the one hand, it's
Are they banning airsofts now too?
No, because the airsoft was named after a rifle that they legitimately banned. So it makes sense. The only counter argument to this is the confusion that happens when you pass something by law through way of order in council without any public debate. It leads to confusion as to what you're actually banning, because there's 1,500 names on this list. Lord knows how they compiled it. One observation is that they didn't compile it overnight, and that this list was in the making for a long time.
So this was also something I didn't quite understand from the video. So maybe it's just me being dense, but maybe you could explain it to me again. I didn't quite understand how this is a thing that Trudeau can just do. You explained to me what it is, but you didn't quite explain to me why he can do it. Is it an operation of the Canadian Constitution, of some executive? Where is he obtaining this authority to just promulgate law out of nowhere?
So it exists by virtue of law when the legislation allows for it to be passed by way of order in council. So there's certain things, my limited understanding. Sorry, I hit my mic. Orders in council, there are certain things you're allowed to pass by orders in council in situations of emergency, for example. They're sort of like executive orders.
Okay.
Other things, when the law allows for it, specifically, you can pass things by way of order in council. And this is a discussion I had with someone, and I didn't really appreciate the discussion when I had it with them, but in hindsight, I understand it now more. The criminal code, the provisions that allow for guns to be banned by way of regulation, specifically provides that it can be done by way of order in council. So the criminal code allows for adding to the list by way of order in council. So it's in virtue of that legislation that was passed in the 90s. I don't know which government was in power then. It was passed that the criminal code would allow for this. So the governor general can say, we're adding this one, no discussion. We're authorized to do it by virtue of the way the criminal code is drafted, and that's the way it's drafted.
Yeah. Okay. So I understand this partially because this sounds a little bit similar to administrative power in the United States, but where an administrative agency can create through rules things that extend or build on statutes to the extent they have it. But the big difference between what we have is even in emergency situations where there's emergency rulemaking, there's still a process that's a bit more extensive than them going to the podium and saying, here is now a list of things.
Oh.
It requires a couple more steps.
It's over. It's over.
And incidentally, this is a little off topic perhaps, but this is exactly why the Wisconsin stay-at-home order just got struck down, because I read that order on stream and it got very specific into Wisconsin state law. But long story short, they did not go through the process of making a rule, and it was determined to be a rule. So they didn't go through the rulemaking process. And even in the case of an emergency rule, there are rules for rules that they didn't follow, and that's why it was struck down by the Wisconsin Supreme Court. So the idea, this is exactly why Wisconsin ban got struck down, because as it turns out, Miss Palm, because that was her name, the woman who did this. No, Miss Palm, as it turns out, you cannot just promulgate this from on high. There are procedures, but apparently not so much in Canada. So okay, that's a
but you know what?
I guess.
One point I wanted to go back to is this ambiguous term, the fact that the law seems to be ambiguous when it comes to assault weapons, but I'm assuming you guys still have the same type of, you guys have the common law court system, right? Where it's kind of that trial by fire. Somebody will come in and the court will then apply precedent and so forth to that particular situation, right? So it's not like there's no definition to it, right? The definition is loose, but I'm assuming, and I think you were talking about aerosol guns, right? That's not the intent of the law, right? I'm assuming some judge will say, well, the law is not intended for these type of weapons. It's intended for these type of weapons. No?
Yeah. Although the airsoft was, I think, a misunderstanding by the public in that it banned whatever model was. When you Google it, an airsoft rifle came up only because the airsoft rifle was named after the original rifle. Okay. So there's ambiguity. Then there's going to be the issue is that whether or not it's ambiguous in terms of what is in fact covered in that order in council, that executive order. But the bottom line is, they decree it. They're going to have 2 years to draft legislation to deal with the buyback provisions and the what's it called when you have a grace period? Oh gosh, someone's gonna get in the comment section, but. Not a grace period, but for goodness, amnesty period.
Amnesty.
That might be there's a 2-year amnesty while you can hold them, you can possess them, you just can't use them, go out in public with them, or whatever.
But that's a grace period. That's a grace period.
Oh yeah, it's a grace period. Yeah, it says they listed individual weapons to ban because they couldn't define them any other way. Well, the problem was the problem to some is that. The legislation and the order in council and the list they have was so exhaustive. It clearly wasn't done overnight. It clearly wasn't done within a week.
Yeah, it was clearly it was sitting on someone's desk somewhere, no doubt.
And in waiting, which offends people. And in waiting for the Nova Scotia tragedy, coupled with a global pandemic where government's not sitting and there's nothing anybody can even do about this, from what I understand, there will be constitutional challenges. They're going to be coming.
It still hasn't been established what firearm was used in that incident. What has it?
They haven't released some, and they've released others, and why they haven't released all of it is
why can't they just announce here are the firearms that were used? How hard is this?
I could give you 5 reasons, but it may go from fact to hypothesizing. Here, let's see. Lachlan Daffodils says, assault weapons is fake English. It was invented specifically to conflate assault rifles with any firearm with modern cosmetics. And that's what I understand, incidentally, is by and large, assault rifles are just They're just rifles, but
Right.
that look mean. They look compact and they look whatever.
So yeah, I was definitely trying to make this point earlier when I was saying how there was that change in language. Assault firearm has a particular meaning, and then when they talked about assault weapons, they were using the similar sounding thing. So these are the same thing. They're actually not. They assault weapons is a category they just invented out of nowhere and start defining it to be anything they want because it sounds similar to assault firearm, but no, assault firearms actually have a technical definition. Assault weapons, not the same thing. Yes.
Kurt, you can probably explain this better than anybody. The bump stock versus
Sure.
semi-automatic versus fully automatic. You want to explain the difference?
Okay, well, a bump stock is essentially a manipulation device that allows you to use a semi-automatic firearm in a way that allows you to effectively fire more rounds per, but still a semi-automatic firearm. So a semi-automatic firearm. Here's your definitions, right? So you can have a single shot firearm, like it only holds one shot, or shotguns sometimes will hold two shots, breech loaded. So you have under over. So you have that. You can have revolvers. And semi-automatic firearm just means you have one pull the trigger, fires one round, as opposed to a fully automatic firearm means one pull the trigger pulls means some number of rounds. That's more than one. Usually infinite number of rounds, but you can also select fire for sometimes less than that. Anyways, so almost every firearm that's manufactured is semi-automatic. There are very few that aren't. And the shotguns are a good example of ones that typically aren't, but almost all pistols, almost all rifles are semi-automatic. One pull the trigger, one shot. Okay, great. Then a bump stock is essentially trying to take advantage of the recoil, because when you pull the trigger, it pushes the stock in. If you're using a rifle, right, it's firing this way, and Newton's laws of motion being what they are, right, equal and opposite force, right? So the bullet is going this way, and because there's equal and opposite force, that means the gun is going this way. So as the bullet is going this way, the gun is going this way, back into your shoulder. So what the bump stock tries to do is take advantage of that movement so that it will automatically re-pull the trigger as a result of the gun's natural recoil. So it is still only firing once per trigger pull. It is a mechanism designed to essentially automate that process to make it simulate semi-automatic fire. And so that was what was used in the Las Vegas shooting. Yes, exactly. And whether or not those bump stocks should be banned is a whole nother set of discussion, but bump stocks don't change a gun from semi-automatic to fully automatic. It's still semi-automatic. And even where they were in that increased fire mode, they are still not as fast as a fully automatic firearm.
Well,
so there's a lot so it's a lot faster than a person could probably do it manually, but it's not anywhere close to as fast as a fully automatic firearm. So it's misleading at best to say, well, it makes it fully automatic. It's like, no, not technically and not even practically, because it's not putting out that number of rounds. It just allows you to manipulate the trigger faster than you might otherwise be able to be. So,
and Tony Nieff says they also banned a gun of which only four exists. This is the flip side, by the way, because some people are saying that's how ridiculous the law was. Others are saying that's how meticulous Trudeau was being. That's the one screen, two films. They banned some obscure weapons. Some are going to say that it was just a ridiculous sweep. Others are going to say he did his research.
It's a hell of a time for a power grab.
And someone did say in chat that it was never proven that the Las Vegas shooter used a bump stock, and that might be true. Maybe he didn't, and maybe I'm mistaken as to what he did or not use.
No, well, I mean, we all know the narrative that we were told at the time.
Yeah,
it was bump stock. There was a whole discussion about banning it. But the bottom line is, as fast as a semi-automatic, or even, well, I guess what's less than semi-automatic? A gun?
No, it would just be where it's, for example, a breech load, like a shotgun, your typical shotgun, which is over, under, or side by side. You've seen these shotguns, right? Well, that's not really a semi-automatic because you're only firing as many shots. You're only firing once, or once breech loaded. So it's a gun that only fires once, or a revolver is not typically considered semi-automatic because it's not feeding from a magazine.
So a semi-automatic,
you could have a breech loaded pistol that only fires once. Or a breech loaded rifle that only fires once. So, and then you have to completely reload it. So they exist. A bolt action rifle, for example. There's another good example. A bolt action where you actually have to manually
pull it back, pop it back in.
So bolt action rifles typically are much more accurate because of the nature of the design. So they're used for precision shooting, long distance shooting. So they're not semi-automatic. But as I said, the vast majority of firearms are semi-automatic.
We got L. Hurst says, come to Wyoming and I'll give you a course in firearms and their history. We'll go shooting and visit one of the largest firearm museums in the world.
I'd love to.
Hurst, I'm screenshotting this because Wyoming is on my absolute list of places to visit. I've never shot a duck. I've never hunted for an animal bigger than the pike that I accidentally catch. So I don't know what it feels like to actually single-handedly end the life of the animal you're about to eat above and beyond a fish. But I'd be game for it. Pun intended, actually, on that one. Anyways, Hurst, I may take you up on that. If I'm ever in Wyoming, I'll call you. Screenshotted. And so the semi-automatic, as fast as you can pull the trigger, you could in theory shoot. The only question is going to be the capacity of the magazine to carry enough bullets to continue to feed the trigger.
Sure.
And so in the States, from what I understand, between Canada and the States, in the States, there is no legal limit on the capacity of magazines.
Yeah, it
depends on what state.
Of U.S. law, yeah. But yeah, some states restrict it.
Like here in New York, it's 10 bullets per magazine.
10 rounds.
Yeah.
Okay. That's what it is. In Canada, it's 10 for pistols and 5 for rifles, from what I understand. Let's see what this guy Martin C says. If you could cook meth without blowing yourself up, you can make guns and ammo with 3,000 CNC machine. Banning tech is pointless. Well, no, because they're banned. They've banned that as well. So I mean, you have that, you may as well be in possession of an illegal firearm. It's just a question of getting caught and dealing with it.
3D printers are going to solve that problem, right?
Yeah, I mean, it's
let's
see what's there. We got using a shotgun full of lead pellets is worse than a slug, but apparently they're not. The lead pellets are only for target, and when you hunt for animals, you don't use lead pellets. Am I wrong about that?
I don't know what they put in the pellets, to be quite honest. I never thought about that hard. I think they're steel ball. I mean, that's the BBs are just little steel balls. I mean, that's actually where the name BB comes from, because BB is also the designation for a shotgun shell with those size pellets in them. So I think they're just steel balls. Okay,
interesting. It says, can we get Viva to come down stateside and do a constitutional audits like 1 and 2A audits? It would be interesting to see a Canadian do constitutional audits. No,
you better talk to Nate about that one. That's a criminal thing. And he'll help you with the former police. Nate, how can we antagonize our police officers for fun and profit?
Oh my God.
Well, you know what? This might be a good time to pivot to do we want to talk Flynn, or do we want to talk Arbery? Because apparently, hold on one second, Uncivil law. Can you explain the NFA?
National Firearms Act? In terms of in terms of creating was it 1933, 1944 National Firearms Act that created the machine gun designations and the initial restrictions of them. I mean, I'm not the biggest expert of them, but that was the first major firearms law in the United States on the federal level that created the initial classifications for machine guns, fully automatic fire, created the scheme for NFA weapons, which includes silencers and includes shotguns of less than 18 inches, so-called sawed-off shotguns, where you have to get permits and licenses for that kind of thing. So, yeah, I mean, the 1934 National Firearms Act is a lot of stuff. What part of it? But yeah, it was the first major scheme to regulate firearms. Before that point, essentially anything was pretty much free for all. It was all state law. So before that point, you could send any gun you wanted in the mail and pretty much do anything you wanted. So yeah, but those are long ago.
Scott Burton says shot pellets are used for small game, and I noticed someone else said that. Here we go. Different purposes. Slugs are not shells. The slugs are for big animals or big game, and pellets are for small game. I remember learning that in my firearm safety class. And we got Trip the left-handed Polak says an argument from a place of lack of knowledge. Single action versus double action pellets are the common shotgun rounds, aka birdshot.
Yes. Well, again, because you can also have double-aught buck, which is called double-aught buck, which is also pellets. I mean, they're really big pellets. So the idea of using pellets to shoot game is not outside that action. Sign that. And when you talk about single action versus double action, typically you're talking about semi-automatic firearms and the mechanism for how they are loaded, whether or not to pull the trigger will also cock the hammer back or not. So whether or not you have to manually manipulate the hammer for the first shot, and this is what is in case of a single action. So for single action, you're looking for a lot of old school revolvers in particular. Some handguns are single action, but not many. Most are double action these days. But single action means that you have to manually cock the hammer back, which also means that the shot that is resulting is a little bit more stable, because now the trigger's only doing one thing instead of two. So it provides advantages and disadvantages both ways.
All right, we got Alizos 360 says, I'm not American, but I keep diving into their debates. It feels like I'm eavesdropping on my neighbor's problems. Yeah, well, the funny thing is the firearm debate is an American problem until we end up running into Trudeau ordering councils, banning things overnight, and then even people who were not pro-gun become pro-gun overnight because they realize what can happen. Like, and I have 5 friends, they go hunting and they have rifles that overnight just got banned. They can't use them. They cost thousands of dollars. They might get bought back for 20% of the value. Bought back. People take issue with that because buyback implies prior ownership in the first place, which some people are saying you never owned it. You don't get to buy it back. It's just basically compensated confiscation. Please talk about the ammo background check lawsuit in California. 9th Circuit and the CAAG thinks it's 50% error rate on denying ammo purchases on legal citizens.
What?
I covered that case on my channel. The district court put in an injunction, which I believe the 9th Circuit overruled the injunction the next day. But the trial court did an analysis of how a citizen could go to buy a firearm. And according to the stats the trial court was using, the thing falsely flagged people as being prohibited something like 15% of the time. And so, as this person is pointing out, the argument, therefore, from the Attorney General of California is, well, that's totally cool because our need is so high. So the fact that 15% of people who are not barred are getting flagged as barred and have to go through extra process is super okay because our need is so high. So those constitutional rights don't matter. And the 9th Circuit Court of Appeals seems to think that that's roughly correct, since, as I mentioned, they overturned the injunction saying it wasn't correct the very next day. They were very fast to say, no, we should have this injunction in place. So yeah, it was a very interesting case. I liked the trial court's decision very much. It was a very good decision to read. It's on my channel if you want to go check it out. If
you can, Kurt, while I'm doing this, post it in the comment section so everybody can see it. I'm going to read this comment here. It says, yeah, saying slugs are for big game and pellets is it's a huge oversimplification. I am trying to oversimplify. I'm not trying to oversimplify for inaccuracy, just for simplicity. Caleb Crow says, soon you're going to see homemade, mostly 3D printed semi-automatic FBC 9.
We're thinking alike.
Well, you're not wrong. I mean, you can't, or just homemade stuff. I mean, it's when I grew up, the Anarchist Cookbook taught us everything we needed to know about that which was illegal. What do we? Oh, let's see here. We got firearm purchases up 62% first quarter, 9 Coronas. Yeah, there's no question. I mean, we see it now. We see it, and we're seeing it in Canada, but we'll see what happens. The other thing is, from the cynical perspective, banning weapons during a pandemic, you don't even have to be a conspiracy. And I'm here, big quotes. Let me just get in there. You don't have to be a conspiracy theorist, because I don't believe in that term anymore, but you don't have to be what people would call a conspiracy theorist to think that is going to rub people the wrong way. Like, how bad is it going to get that while we're on lockdown, they need to ban guns overnight with no public debate and criminalize it? Like, that makes me apprehensive. Nate, Kurt, do we talk about the people, the developments in Arbery? What were the developments? That apparently they had told the father to go scope out a place for burglary, and therefore it was not.
What?
I want to see the Anarchist Cookbook. Oh, geez. YouTube's going to react. I have no doubt this stream is not getting monetized. I'm not even going to try. I might try.
Just for the heck of it, I should just read the entirety of the Anarchist Cookbook onto a live stream. I think that'd be great. Just read the whole damn thing out here.
I had a physical copy of the book. It was a black book, and it was like 8.5 by 11. Whoever lent it to me never got it back, and we lost it and could never find it. Let's see what we've got here. We got okay, whatever. We'll get that later.
Equal parts orange juice and the gasoline, right?
Well, I did the one that I almost got in big trouble for, which was the saltpeter, potassium nitrate, sugar, and if you cooked it, it would turn into like a sludge, and you could like form it into smoke bombs. And I was doing it when I was a kid, and it exploded in the kitchen while I was doing this. And I still have scars, which are, I don't know if you might not be able to, you might be able to see them on my hand here, right there. That's one. Anyways, my Halloween smoke bomb, I was not trying to do anything illegal. I was just going to use them for like smoke bombs for Halloween. Exploded in the kitchen as I was cooking it. I have some scars on my feet. Modern firearm laws are cosmetic in focus and ineffective. Most cases of illegal criminal use, those persons were barred under existing laws. There's no question about this. Like, first of all, the majority of Canadian gun crime, as with America, is not assault rifle. It's not long arms. It's not rifles. It's handguns, which are already which are already restricted in Canada. You want to own a firearm, you got to get your PAL, your whatever the license, your PAL. It's called a PAL. Whatever. It's a license, a specific license you need to get, prohibited something license. You need to get a license to own a handgun. And even when you own them, it's not for self-defense. It's not for home defense. It's for shooting at a range. And you can't keep it at your house for home defense. You can't keep it for self-defense. And they're already prohibited. They're already regulated. They're already whatever. But that's what the majority of crime is about.
So you want to talk about this Arbery situation?
Yeah. What's the news?
So as far as I understand, and if someone wants to correct me on the facts, I'd appreciate it. But as far as I understand, while there was video of this incident happening, the people who ultimately tried to stop Arbery didn't have access to that video at the time and didn't see him commit a crime in real time that they would be responding to. My understanding, again, if someone wants to correct me on the facts, is that one of them recognized this individual from prior tapes, perhaps, and thought he matched the description of someone who was doing this. And as on that basis, decided to try to track him down. But under Georgia law, that would not qualify for a citizen's arrest. Georgia law, to do a citizen's request, requires you to have immediate knowledge of a crime, not past knowledge. So even if you recognized the individual from past video, that doesn't give you a basis for citizen's arrest. So unless one of these individuals saw him do it at the time it happened, then it's not a valid citizen's arrest. And then even if it is a citizen's arrest, I think that they used excessive force in conducting that arrest. And so I think that they are in some sort of legal trouble. But my view, based on the facts as I understand, is there's no valid claim for a citizen's arrest.
So that was instant. What in the stream that I did with Barnes, I'm just screenshotting because we're at 1,000 viewers, which is so pleasing to my eyes to see that round number. Barnes is saying when it comes to a felony, it's different than a misdemeanor, and if it comes to a suspicion of a felony crime, then you don't have to actually catch them in the act or in the process of. If you have reasonable suspicion. Now, Nate, you had something to say about that.
Well, let me read the statute. It says a private person may arrest an offender if the offender committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion.
Right. So the way I read those sentences, I read them in context. So I don't think you can arrest on the felony unless it's being committed in your presence. So it's like it gives this additional qualification. So the way I read the statute, it says if it's a misdemeanor being conducted in your presence, yes, you can try to effectuate the arrest. If it's a felony, however, and being conducted in your presence, because I'm still reading that clause from the first sentence over, I'm reading it through. If it's being conducted in your presence, then yes, you may do this additional thing. So I don't agree with Barnes's reading of the statute that if you have belief of a felony, irrespective of you seeing it in your presence, that gives you grounds to arrest. It's not the way that I read the statute. So I disagree with Barnes's reading of it.
Well, I know the way it works here is that if you're a private citizen and it's a misdemeanor, those are less serious crimes. So you would have to be actually either a witness to it or it happens in your presence. And even when we say in your presence, let's say if someone gets smacked and it's behind your head, but you hear the smack, you turn. That's also considered in your presence. So in your presence means in your physical, in that physical presence where if you observe it. Then for felonies, it's a little bit more relaxed. It's not as intense. You don't have to physically. It doesn't have to happen in your presence, but then you have to have a higher level of knowledge that it actually happened. You know, maybe the witness is saying he just shot me. You didn't see the shot, but you see the person running, or a woman saying this person just assaulted me. So that's kind of the way I'm reading this statute here. Is that for the minor stuff, you have to be. We want you to be more sure. We want you to be there. But for more serious stuff, you can do it at the same level as a police officer does it, which is probable cause.
So this apparently is the update. Scott Burton says, into the recent news updates, property owner has text instructions from police to call one of the men if the incident, if they had another issue on their property. Still unclear on all the details. So let's even assume that our understanding is that it's going to be the police said, okay, guys, if you see this, arrest the person. It's gonna. My issue is, like I told Barnes, and it's still my. It's not a question of being pro anti-gun or pro or anti-theft. Even if they were in uniform, I think we would still be having the same discussion as to whether or not this was excessive use of force by police officers. And if they're in uniform, it becomes a little bit different. If you see, an individual, an accused, fighting or getting into an altercation with a police officer, and then the issue would be like, if it were a police officer not in uniform doing this, where the individual didn't know they were police officers, be another different discussion, which we had when people bust into people's houses unannounced, don't identify that they're police officers, and then get shot, and say, yeah, it's self-defense. So even assuming the police asked these guys to do it, you might have some incompetence on the police force. It might not necessarily justify what happened.
If the police actually told them to do it, then you have an issue that they maybe became agents for the police, which raises a whole another set of issues. But I doubt they were that clear about it.
No, but they're acting under color of state title, right? The state is state law allows them to make this arrest. So effectively,
I don't know about that.
Effectively, they are state actors in effectuating an arrest under color of state. Yeah, they are state actors. For that instance,
you might be right. I, honest to God, had never thought about it before this moment, whether or not they would be state actors or not.
Of course, the Fourth Amendment has to apply. They're making a seizure under color of state law.
I honestly don't know.
But hold on. If thinking just lawyer not knowing the stuff, that might apply to their defense to murder, but not necessarily to their defense to wrongful manslaughter or whatever. Like they'll say, okay, look, we were just that, because to say that wouldn't change anything vis-a-vis their relationship to Arbery, because Arbery has no idea they're state actors when they're doing it.
It would in the sense where if they're state actors, then the Constitution applies, because Constitution doesn't usually apply to private parties. But what makes a private party a state actor is if you're acting under generally color of state title. And I think in this particular instance, these people are using the state has passed a statute allowing you to arrest people under certain provisions. And like, for instance, the Fourth Amendment says you have to, when you effectuate an arrest, it has to be for probable cause. So the state can't then pass a law and just say you can go arrest people without probable cause. That would itself violate the Constitution. So I believe these people in this particular instance will be recognized as state actors for the purpose of this arrest.
But and then even assuming that,
but that's an argument. That's just an argument.
Yeah, but it's not legal advice. What protocol would they have to implement if they're state actors? Presumably, they don't just say, "You should know I'm a state actor." There's something they say, "I'm. This is a legal arrest." Miranda rights and all the other stuff.
I don't think your argument is fully without merit, but I'm disinclined to think it's right, because I think what this law is intended to do in its most pure application is the shopkeeper who can detain the person who's trying to take stuff out of the store and detain that person. I don't think that person at that moment has to comply with Miranda. I don't think if they start asking questions that those can't be admitted at trial. I don't think your argument is trivial, but it seems more akin to a license that would be authorized by the state, but just because you're licensed doesn't make you a state actor. I mean, there's case law on that. So I think you have an argument here, because the police function is more core governmental function. And so since it's something that's more core governmental, the argument changes. But I think that,
because
yeah,
like my argument, well, I would say my argument would simply be, when the person makes the arrest, where are you taking him? You're taking him to believe, what does an arrest mean? Who's authorizing this person to make this arrest? I think at this point, it makes it clear. If the state is authorizing this person to make an arrest under these circumstances, then the Constitution should apply to them as state actors.
I don't think there's any difference between using the word arrest and using the phrase seizure of the person. I think both are the same there. So if I'm arrested, you have seized me as a person. So again, the shopkeeper has arrested me because they've seized me, because they're forbidding me from leaving. So they've seized me. Mm-hmm. So if they don't have license to do that, then it's kidnapping or something else. It's proper. But if they have license to do it, then it's proper. So yeah, I think it's
I would be, even if they have the license to do it, if they're authorized or justified, there's presumably some protocol, because their authorization has to be conveyed to the individual in a manner that's discernible to the individual, as would be in uniform for a police officer, and not just like somebody showing up with a gun and I don't know if I'm getting detained or robbed type thing.
You know what? Can we roll it back? Because one thing I want to do, let's roll. When I first heard this case, and I haven't mentioned this to you, but when I first heard this case, I remember it was on like ABC News, Good Morning America, and the way it came over, and I'm going to be very serious, was there was somebody who was just jogging down the street. It was two people in a truck, stop them. They happened to be Caucasian, and more or less gunned this guy down. And it was, and the hashtag was, jogging, and now you got people jogging all over the city, because of this individual. And that story seems to have changed dramatically. And it's interesting because I haven't seen anybody call that piece out. Because don't get me wrong, there's a huge history here of racial intolerance, the black codes, we are sensitive to this type of thing. But in this case, this wasn't someone who just jogging down the street and who was just being attacked willy-nilly. There's a lot more complexity here. And I think the media did us all the disservice by forcing people to kind of make this, by putting it out in such a way where it made it seem like it was just so black and white, when it's not. This is very, very, very gray.
No, there's no question. Incidentally, Kronos says Uncivil Law, it's possible the ex-cop recognized him from his on-duty life. One of the hypotheses that Barnes talked about, not unsubstantiated, but we don't know. It's possible, which might explain why he reacted the way he did. And like I said, Nate and I had this discussion when we were talking about it the other day, and my bottom line was, there is more to the story. It doesn't necessarily change the problem as to what happened. It certainly colors the way the media reported on it, but there's two separate issues: the way the media reports on it and what actually happened. And incidentally, so Ricardo Ospana says, "Can someone say qualified immunity?" I mean, I'd be curious if anyone who's not in uniform identified as a state actor is going to get qualified immunity when nobody knows.
Yeah,
knows who they are when they're doing it.
That presumably would follow from Nate's argument. If these are state actors for the purposes of 1983, then presumably qualified immunity would also attach. So yeah, I don't know.
And so Aaron Porter says, a bit of an aside, but tell your wife, Viva, her Pop-Tarts look great and your little boy's too cute. The Pop-Tarts were high in butter, high in sugar, and high in fruit. They were good. Viva, strongly disagree on your police officer analogy. An officer can stop on reasonable suspicion. At that point, it's self-defense when you grab the gun. Nobody's going to disagree with that. The question is going to be, first of all, if they're uniformed police officers and it goes down that way, I don't think there would be any question. I think we can agree with that. Anybody, if you ever see an individual doing that with a police officer in uniform, it's a different issue, because in theory, you can take for granted an officer in uniform is not going to shoot you when they pull their gun, barring other things. Somebody on the street who I don't know is a police officer telling me they want to talk at gunpoint, I don't know what they're going to do. So the whole dynamic changes. So, I mean, I agree with you. I don't think we disagree on this point, Dapper Dave.
Well, what do you guys think about this argument? Because I was playing this out in my head the other day. I think both sides have a very good stand your ground argument. I believe first, the gentleman in the truck. They went up in front, right? They stopped the truck. They all got out with guns pointed, stop, freeze. And this gentleman lunged at them. And and then obviously he got killed. So they can say they were standing their ground and he came and lunged at him. Even though they were screaming stop. But then I think he has the same argument too. He was running. These people were chasing him. He hadn't stolen anything. Now they stop and they present guns and it's fight or flight. So he fought. He jumped. He doesn't know what these guys are going to do. They're standing in front of him with a gun. He was standing his ground. So now so now at what point when do those two rights conflict?
No,
because I think both sides have a legitimate argument at it.
100%. And it's in a G3Y3R says, being a security guard in California, or either California or Canada, I'm not sure, it's California. They taught us for felony citizen arrest, you need to have a reasonable assumption the crime actually took place. Example, man with a knife and covered in blood may be criminal or just butcher. This is the thing, like a lot of people, first
That's
of all,
why we teach it here in New York too. Same thing.
Well, and a lot of people are saying, Arbery assaulted them first. In Canada, it's a crime to point a gun at someone. It's a crime to approach someone with a gun. It's assault to have a weapon and give the impression you're going to cause harm. That's assault legally. So to say that he assaulted them by grabbing their gun, if someone approaches me on the street with a gun, I probably don't react that way, but I consider that assault. Even if someone pulls a gun on me as a joke, I consider it assault. So, but then it gets into it gets into the citizens arrest laws of Georgia where you're allowed to open carry. So obviously having a gun on you is not assault in Georgia. Pointing your gun at somebody, even as a joke, I suspect would be a crime somewhere if there's no better reason to point it.
Because it's brandishing.
So,
there's a difference between open carrying and brandishing. And because of what these people were doing in full context, I think it's more brandishing than open carry. But that's my view of the facts of the situation. Yeah, for sure. And that's where everyone's going to look at that video and get a different impression. Is people are going to say, oh, they were just holding them, they weren't brandishing. Others are going to say it's brandishing. Others, you're in a pickup truck, two guys, both of you are armed. This individual clearly was not armed. Whatever. And we can appreciate the different takes on it. But okay, I'm nobody says, I believe it's still false imprisonment because they were attempting to detain him by force without identifying themselves or their purpose. But we don't have enough from the video to know if they properly identified themselves. If they didn't, we just don't know. But you could look at that one clip. In that clip, they were not identifying themselves as you're under arrest. Here are your rights. And the shit.
But to be fair though, if let's say if one of you two gentlemen happen to be stopping me talking about you're under citizen's arrest or what, it's almost laughable to expect a reasonable person to stop or to not be afraid, especially this truck. In the context of it, this truck chasing him down the street and then running up and pulling up in front of him. It's the situation's already tense enough where they wanted a confrontation, unfortunately, and they got the confrontation I think they didn't expect. You know what I mean? Because they intended to impede his progress, to stop him from going wherever he wanted to go. And now one screen, two films. You got Justin Lloyd saying it's not murder. Ahmad ran 400 feet directly towards them. Not to pull the lawyer. I want to know how you're measuring your feet because I saw the video too. He went left, he went right. I saw what happened. But by that point, you have two people in a pickup truck with guns looking for someone, and they found someone. And then what does he do? Find me. Maybe I run into the forest. Flip side, maybe I don't run into a forest with two people with guns because that's not the most open place to be with two people with guns. This thing about this felony burglary without.
Yeah, I disagree. I disagree that Ahmad either committed trespass, criminal trespass, or felony burglary.
Yeah,
burglary. It's not criminal trespass because he hadn't received notice from a person and it wasn't posted. And it's not burglary because he didn't enter into a dwelling place with the intent to commit a felony therein. It doesn't meet the statutory elements.
Just to push back, Nate, to push back on that, without the intent to commit a felony, we don't know what the intent was. So people are going to say,
"Well, yes, that's true." But based on the video, we don't see any actions from which we could infer intent. So there's no facts that would suggest any improper intent. He went in, he looked around, and he left. There's nothing there that suggests it's. So to my mind, it's not felony burglary. It's not criminal trespass. I don't think it qualifies as a valid citizen's arrest because they don't seem to have the right knowledge. So then here's your self-defense law 101 analysis. Whoever acts first loses in terms of the first offense, in terms of self-defense. So I'm without right. I pull a gun on you. You now act against me. I no longer have a self-defense claim because I was the first one to act. Even if you suddenly pull out your gun or pull out your knife or pull out whatever, I don't have a self-defense claim because you're responding to the thing I started, and I was without the right to do so in the first place.
This is like
so if these people, assuming arguendo, as us lawyers like to say, assuming arguendo, that they were without the right to do so, and they were posing a clear and imminent threat of death or grievous bodily harm, then Arbery has a self-defense right. That allows him the right, if he so chooses, to run up to them and confront them physically and attempt to take their firearm. And they can't then say, oh, wait, I'm being attacked. I suddenly have a claim. No, because you're the one who started this rodeo. You don't have a self-defense claim at that point. So the way that I perceive the facts at this point, I think the better end of the analysis, and I'm not saying it's conclusive by any stretch, because these are all factual issues that have to be decided by a jury, and it can be read a whole bunch of ways, and you have to be seen. But based on what I'm seeing so far, it appears to my mind that this is some variant of homicide. That's what I think, based on the facts I have so far.
Well,
and I disagree with Barnes, even though Barnes is a smart guy. Sorry, Barnes.
Yeah, I disagree with Barnes. Go ahead.
Let me get these quickly. I'm going to get problem with your agreement is that the guy was not detained before he was rushed. I think that's some of the consenting. Al Dente says, please look at the picture of the lawyers and give us your opinion about their hairstyles and the prosecutor's suit. Okay. But thank you, Al Dente. Hold on. Let me see. I think there was one other one here. Sergeant. Oh, I missed it. Where did it go? I saw a few. Oh, boy, hold on. No. I missed Sergeant Bach. Okay. Okay, 161 black people killed in Chicago since January. No media attention. Crickets. You're all contributing to the problem. Look, there can be separate problems without contributing to another problem by not addressing another. There's many days in the week to address problems. So there's undoubtedly multiple problems going on at any given point in time. Not talking about all of them is not contributing to any one of them. Ted Skovlanek, 2. Did you hear hear Officer Rash texted the homeowner about the McMichaels number and told him to contact them if we saw someone in the house? Yeah, no,
somebody else just mentioned it.
Yeah, we were talking about that, but and then even still, flight from trespass implies intent. Flight from trespass implies intent.
Flight can imply intent, but it can imply criminal guilt. I mean, Nate will know that very well from his.
It
can imply.
I know, but it's enough for a stop, but not an arrest. You know what I'm saying? It gets you the reasonable suspicion. If you see somebody running from, I got to be a little bit more vague, because if I see somebody if I see a dead body on the floor, someone holding a knife, and that person starts running, that's different than if I just see somebody running down the street. You know what I'm saying? And the law treats you, in one instance you can stop, and that'll be a Terry stop, but that's not enough for an arrest. In another instance, you have probable cause, so you can effectuate an arrest. I think here, like Blackleaf was saying, based on the facts that you have, I don't really see a burglary, because number one, the house is under construction. So is it a dwelling or not? I'm not sure if Georgia law has even answered that question. But assuming that it is a dwelling, then you have somebody who's walking to a house and just walking out. I don't see, even if I just assume you do have trespass, from what it seems like we're getting now with these people saying that the homeowner was scared enough where they said contacted the police if you see this person. That still, that doesn't give you enough, where I think under what we've read here in Georgia law, it gives you enough to then go and actually try to effectuate a felony arrest, because you would need to have a burglary for that. But otherwise, I think this is just not. I think this is less racial bias than more tragedy. It's a tragedy that a former law enforcement officer doesn't know. You just follow and, let the police know where you are, because the police were already on his way. I think they wanted to play hero. We called them buffs, and just stop the guys and arrest them and be the heroes. And it just went bad. He had his son out there, and that was unfortunate. And I also think that this guy wasn't the angel that we've been led to believe. You know what I'm saying? But when you put all these things together, this man should not have lost his life for just looking around in an empty house and running away. That is just unacceptable.
No question. I mean, here it says, Juan says he didn't have intent to commit a felony. The items that Arbery took out of his pockets before charging, I don't know what that is. I'm going to see the comment underneath. Combined with his shoplifting record, but no, they didn't know his shoplifting record when this took place. He may have had a shoplifting record. It doesn't justify the level of escalation that this went to.
Yeah.
Now, Captain Putz says he had a hammer he had and dropped a hammer just before running. I don't know. I haven't heard that from the evidence. So this is why everybody's looking at the video and sort of seeing something different.
What does that mean? How does that change any of the facts? So he dropped him. That makes him more sympathetic to him now because he had nothing. If he'd at least had a hammer, you could at least said he had a hammer. But now
that does change the analysis because assuming he didn't walk into the building with a hammer, which seems plausible, then it would imply he took the hammer from the building.
Yeah, but that was
some sort of criminality there, which does change the analysis. But then you still have to go to what they knew and what they didn't know, unless they saw that happen. Then you still have a problem with the citizen's arrest.
Well, and I from what I understand, I have not heard them having testified that they saw him drop stolen material or a weapon. So if you drop the hammer, presumably we're only focusing on that because it's either a weapon or stolen material. I didn't hear that McMichaels even said that from what I understood, but I don't. It is a rapidly evolving situation. Miles Moya says Greg was on the phone with 911 when he was in the bed of the truck. Well, you should be able to overlap some audio with some video then. Mm-hmm. But even still, you're on the phone with 911. It's not a question of letting someone get away with theft. It's let the police do it because, when two citizens come up with guns and try to detain somebody, it's who thinks it's ever going to go well? What you're going to lie on your stomach on the ground and let two people who are not policemen detain you with weapons? It's like it doesn't go anywhere good. So we got, if this is political case thing, Trayvon Martin. Well, there's no question it's being politicized. It's being politicized in media side, mediatized.
I agree with that.
That's what politics and that's what media does. It's terrible.
And I thought the Trayvon Martin Zimmerman case came out the right way based on the evidence that was there. That I thought that that they didn't prove beyond reasonable doubt. I thought Zimmerman should have been acquitted.
Well, but
so I don't know that I'm particularly biased. I'm just trying to read the evidence as best I can based on what I know right now. So.
I don't know. I think it's Zimmerman. I think it's maybe an overreach because I think the charges were overreaching.
Yeah, I think it was overreach too.
I think you could have got criminally negligent homicide or something like that. And I think you could have got that because I think he was negligent. He had a gun. He called 911. They told him not to follow the kid. That type of stuff. That really gets to that criminal.
The prosecutor over prosecuted for the political reason, and they got burned by it.
And they got burnt by it. Yeah. So.
Okay. We got hold on 1 second. We had something. I missed it. Okay. It says Georgia law doesn't require the dwelling. It's for trespass. Fine. I don't think it has to be a dwelling for trespass. I think
in second degree, that's true. In first degree, it does have to be a dwelling. In second degree, it doesn't. That's true.
And then let's see here. We got how do you know McD didn't know he had a record?
Irrelevant.
Yeah.
It doesn't matter.
Also, nobody knew that right at the time.
And
it doesn't matter as to the citizen's arrest. Even if I knew for a fact he was a felon, even if I knew for a fact that he committed all kinds of crimes in the past, it doesn't matter. Yeah. Even if I knew that whatever, it doesn't matter. All I care about right now is what is justifying the citizen's arrest. And at least the way I'm reading the statute requires some sort of imminent knowledge, requires things that are not there. So the way that I'm doing the chain of analysis, none of that stuff matters. Sure, he's a criminal with convictions, and I knew about it, and therefore what? It doesn't seem to matter.
It's what you know at that moment, what's happening at that moment.
Yeah. We got a Don S super sticker, which is I still don't know what super stickers are, but thank you. What's the difference between a super sticker and a chat? No longer a hate crime. Well,
yeah, I don't think it's a hate crime. At least under U.S. law, you look to motivation to determine hate crime, and it doesn't appear. The motive here was because of race. It appears more likely it was vigilantes who went off the rails rather than they decide it would be a good idea to kill a black kid today. So I don't think it's a hate crime as best as I can tell.
Did they have cuffs? They must have really this must have if you stop the guy, you're gonna cuff him. You know what I'm saying? I'm trying to figure out how far did they go with this thing.
We got Dapper Day says the one thing I noticed with this case and Trayvon Martin is the lack of a secondary weapon, pepper spray baton, should be part of citizen's arrest. Yeah, or I might be game for strength or increasing prohibitions on citizens' arrest and how they can be affected, because you have citizens showing up arresting other citizens with guns. You don't know what's a citizen's arrest versus a robbery anymore. Like someone says, I suspect you just committed a felony. Stop. Like, dude, if I know I didn't commit a felony, I'm going to react very differently to that type of citizen's arrest, even if the law provides for it. You have a law enforcement, for non-urgent, non-violent, non-felonious behavior, when there's no risk to anybody. I could imagine prohibitions on no risk to anybody, certain rules. You can't escalate it to where it becomes, assault, weapon brandishing, citizens arrests for unarmed individuals. Corey Peters says the father was part of the prosecution of Arbery for a TV theft and possibly recognized him based on Barnes' commentary. Correct? That's what Barnes said. Even Barnes.
I don't know about that.
Yeah, even Barnes said it was a theory, not proven. So, but even still, this is not a question of getting back at people for TV theft or whatever. It's not the way things should go. It's just not the way things should go, even if the law allows for it. But Barnes did say, if it's a statutory moral thing, it's a different thing than being a criminal thing. Greg 911 audio sync video by Ham Solo. Ahmaud Arbery video synced with Greg Michaels. Okay, link will be interesting. People will learn.
Yeah.
Do you guys see the video of the black man making a citizen's arrest? This also happened in Georgia. I haven't seen that. The citizen's arrest, man.
Well, I'll tell you here. I know citizens' arrests can sometimes be dangerous because let's say you're wrong. If you're wrong, you've now you could have committed a criminal act, because that could be everything from kidnapping to to assault. Yeah, so citizens' arrest are something that are strongly discouraged, because when the police are wrong,
you have to be right.
They're indemnified. Yeah, when the police are wrong, they're indemnified by the state. When you're wrong,
arrest, you have to be right.
Nothing. Yeah, so that's why they make sure to say do you absolutely know, were you there? Did it happen in your presence? Because if it didn't, then you're really you're taking a big gamble with a citizen's arrest.
Sergeant Frank Rock, I saw your name before and I think I missed the super chat. Police have implied immunity. How come it doesn't cover citizen arrest?
I don't know. It doesn't.
No, it doesn't cover citizen's arrest. I don't think so. But if they become state actors, it may. It's an interesting question. I got to look at the Georgia law to see, because there's no way I cannot see they're doing a traditional police function. They are making arrests. I don't know, taking them to precincts, testifying in court.
So here, someone says vigilante assumes a crime. These are hunters looking for a victim under the guise of law as their hunting license. I don't think they went hunting, because I don't think it would have ended before the way it ended if they were out, hunting in that sort of way of describing it. I just think you have two people with guns causing a confrontation, shit hits the fan, and that's what happens. If they were out just to kill, Arbery wouldn't have gotten that close to them. It would have been over earlier. There wouldn't have been the person recording it to make sure that it was done properly, or to have video evidence of what they did. So that's sort of what I would describe as like the media description of it, to try to get people enraged and racialize the incident. I just think it's people not thinking ahead and just jumping into a situation that necessarily escalates. Oh, Super Chat allows a message sticker cheaper, no message. Oh, by the way, thank you very much, both of you. No, so I don't think they went hunting. I mean, I don't think it was the lynching that the media described it as. I don't think it was like some dude jogging and they went out and say, hey, let's go do this, because there wouldn't have been somebody recording it. They wouldn't have been getting instructions. They wouldn't have been in contact with the police. There wouldn't have. It's just people not thinking, where's this going to go? Two men with guns stopping somebody on the street. How do you think it's going to go? Oh, he's just going to roll over and say, okay, arrest me. Like, dude, I don't know what they're doing. They're going to kidnap me, take me to some far off place. Like, who the hell knows what they're going to do?
It's the one wild thing about this case is that I think if people just stopped just looking at it through these lens of this racial lens, and just look at it for what it is. This neighborhood had obviously an issue with people going into these houses, right? And these people were a little bit more sensitive to that issue. This person who seems to be one of the people who were just going into the houses. This person may have not stolen anything, may have not done anything, but these people were hyper vigilant in that area. He does this. They want to make a point. They say, we got a guy. It's the middle of the day. They called 911. They chased the guy down, and you had this confrontation here at the end. And I don't think it was. I think it was more motivated by just the community saying, hey, we have this thing. We want to stop this problem. than more of a we want to go kill the next black man who's running down the street. And and that does happen here in America. I want to make it very clear. That does happen, and there are real racial injustices out there in the United States. But I don't know if this one is one of them, or it's being portrayed to be one. But I just don't see it that way at this time.
Yeah.
Well, let's hear. Justin Loy says, "Uncivil law. You think Ahmaud had the right to run up and attack a man with a shotgun?
Yes.
Is that safe, logical? I think you're biased. But I mean, bias. I don't know what bias means.
Well, is it safe and logical? Is asking a completely different question. That's a different question.
Yeah.
Do you think I have the right to? Yes. That's a legal question. Is it safe, logical? That's more a practical question. I don't know. I'm not asking. I'm not here to answer practical questions.
But just think about it. If somebody picks the gun and points it right at you in grabbing distance, most people grab the gun. If somebody puts a gun at you, some people freeze, but most people just even put their hand and grab the gun.
I mean, it's self-defense law 101. I mean, it's not particularly controversial. The aggressor. You without right pose an immediate threat to me. As a matter of self-defense, I have a right to engage you if I so choose. Now, should I do that? Who knows? But if I choose to do that, even though I'm unarmed and I want to try to wrestle the gun away from you, yes, I have every legal right to do that. And if I gain control of the firearm, you now can't say, oh, now he's armed and engage me because you're the one who started this. So I have a self-defense right and you don't because you're the one who created the problem. So should you? I don't know. Is it safe? Probably not. Is it logical? I don't know. Debatable. Is it legal? Yes. It's self-defense law, clearly. No problem.
And look what's happening. You have a man with a gun trying to impede someone else's progress, right? He's trying to impede this person's freedom. He's trying to take this person into custody.
I mean, let's just make it even simpler than that. You without right to do so, pull out a gun. I pull out my concealed carry firearm and I blow you away. Are you going to say I can't pull out my concealed gun and blow you away? Of course I have the right to blow you away. You're the one who started this. So even if I don't have a gun, I can't attack you legally? How does that make any sense? I can't attack you with my fist when I can attack you with my concealed carry firearm? That doesn't make any sense. Well, I have the right to shoot you. I have the right to hit you.
That's something that, I mean, Justin, I mean, it's the legitimate issue. It's like, if he had a concealed carry permit and he was, and he triggered, like, and boom, and he pulls it out. I mean, it's self-defense in that even if we're all taking for granted he was committing a felonious crime and therefore should kneel down on the pavement and allow for arrest. Yeah. But people approach you with a gun on the streets. There is no logic anymore. There is no, I don't want to say logic safe. He did what he thought was more likely to lead to survival. And we're taking for granted some underlying facts. But no, I mean, what anyone else would have done in that, I know I'd be running away and not towards, but running away, you might end up getting shot in the back if they think you're fleeing type thing. It's who knows? There's no logical decision making at that point. It's all impulse.
People are so criticizing me, saying, well, he never pointed the gun at Arbery. Okay, well, if it was brandishing, it's still posed. The question in self-defense law is, are you opposing an imminent threat of death or grievous bodily harm? That's what's triggering this. So without a right to do so. So whether you're pointing the gun at me is not the operative question. That would certainly help, but it's not dispositive. So if you have a gun in a position that's essentially ready, in a ready position or close to it, and you're posing, again, an imminent threat, you haven't attacked me first, you haven't pointed at me first, but if you have triggered that step of posing that imminent threat, that gives me a self-defense right.
No, it's like,
okay. So I don't know. I don't know why this is so complicated. It's self-defense law 101. This is why I believe in concealed carry. This is why I believe in self-defense. I believe you have the right to carry a firearm. I believe you should carry a firearm. I believe you have the right to self-defense. I believe if someone says, give me the money, and you decide to shoot them, that you're in the clear. So I'm not quite sure why it's so controversial, this idea that if they were in the wrong to do so, that he didn't have the right to engage them in self-defense. I'm not quite sure. Why are people arguing against self-defense? I'm not quite sure what's going on here. It's very confusing to me.
The idea is like, some people are saying, well, they didn't point the weapons at him.
Okay.
Two people stopping something. I don't care where the gun is on you.
Yeah.
On an open street and I see they have a gun, they could be pointing it at my head or not even having it in their hands. it's relatively speaking the same sort of threat as far as I'm concerned. If I'm a non-criminal,
Well, hold on.
If you reached into your pocket and told me you were reaching for a gun, even if you weren't, I still would. If I believe you, I still have self-defense. So I don't understand this.
But maybe people don't understand what was happening here. He's running down the street, and these people are in a truck trying to stop him while he's running down the street, and they pull ahead to stop in front, and one of them gets out with a shotgun. So yeah, the situation, you have to look at the totality of the circumstances to see whether he's acting reasonably in that situation. Which I don't think most people would say that yes, he didn't have a right to self-defense. People are holding guns in front of him. You know what I'm saying?
People are going to say to push back Nate. People are going to say he could have run in the opposite direction. He went to the driver's side and then beeline 90 degrees to the younger one.
I'll give you that.
That's standard ground, though. He doesn't have to.
But let me say this. Let's say they jump out the truck with the shotgun and he pulls his gun and shoots them.
Would
the people in the chat have a problem with that? Because I think he would have had just as much right if he had a gun to shoot that guy dead when he saw that guy jump off the truck.
No, and people, I mean, you have to be fair about it. People think he could have run in the opposite direction. Trying to outrun a bullet is a sort of an illusory way of looking at the situation. He could have run through the forest. They're armed people, and you don't know what they're going to do when you're running away from them. So running away is even more vulnerable than running at type thing.
I also like the people who say, "Oh, these people were doing nothing more than open carrying their firearms." I'm like, really? They were open carrying their firearms. They weren't exactly just standing on the sidewalk, with their firearms in a position. They were standing in the middle of the street with their truck in the middle of the street, creating a barrier. It's a little bit more than just open carry. The pushback on you, Kurt, is going to be there were no sidewalks there, so the only place for him to run was in the streets. They were, everyone was standing in the dead middle of the street. They're obviously their obvious hope. I mean, their truck could not be any more in the middle of the street if they tried. Their obvious hope was to prevent him from passing that point.
It's a little
bit more than open carry.
I think people are tying. I'm saying I believe they're guilty of a crime. I believe this was an unjustified killing. This was a homicide. I'm saying, whether it was criminally negligent or whatever, the courts decide that. But I'm saying this was a homicide. This was an unjustified killing. That doesn't mean I'm saying that it was racially biased. I don't believe it was racially biased.
No, the evidence doesn't support that right now.
I think these were two overzealous people who had some history in law enforcement, but I there's no means think that they were just out to kill the next black guy. I think that this killing was unjustified, but I do not think it was racially biased. And I hope the chat understands those two aren't linked together.
No, I think most people are going to understand. They're just going to disagree. Some people are operating on the mental framework that he had committed a crime, he was guilty of it, and they were just trying to detain him. Others are going to say, and my bottom line is, people accuse me of sanctioning or tolerating theft. I don't care if he did in fact commit trespass or whatever. That's still not how you escalate this type of situation where there's no risk of immediate harm. It's not like a rape or an assault. It's not like he's beating somebody. He stole some property. Okay, call the cops, and it doesn't escalate past that. Whereas if there's another situation, take out the guns and do what you have to do. But no, I don't think, and I think we can all agree. I don't think many people are buying into the racial depiction of this by the media, except for athletes who tweet quickly before any of the news is in and then can't apologize because nobody can apologize these days. But I don't think the racial aspect, I think, is going to fade away. The innocent, jogging in the streets narrative is going to fade away. But then it still doesn't change anything. Okay, so he might have been guilty of something. He might have stolen a TV 5 years ago. He might have been scoping out the spot to rob it later. He might have been stealing copper. He might have been stealing tools. Does any of this? Is this the society that we want to live in, where it escalates to this, as opposed to just letting the cops deal with it because they're already on their way type thing? Okay, Matthew Maddox says the property owner got notification of trespass. Here's my speculation: they called McD, said he's there. Does this change anything? I think we've got to that. I mean, it's going to be a question of perspective. Midnight in Exile, what was your super chat? Don't put another super chat in. Put the comment in. What your question was. I'm going to get to it as soon as I see it. I apologize. I undoubtedly have started missing super chats as nothing more I can do.
I don't mind people who disagree with me. It's just very confusing because I'm trying to give a legal analysis, and the arguments against her are a little strange to my mind. So I don't mind people disagreeing with me. People are free to disagree with me.
No,
I'm not going to attempt to ban you on chat or something. I'm not going to get butthurt about it. It's just like
people are operating on the basis.
You guys express your opinion, and I express my opinion back. So it's like, okay.
And to understand them, people are operating on the basis that he was out there committing burglaries, that he was trespassing, scoping out this joint either for the day or for the night, and he resisted the arrest when he saw them. He recognized McMichael and charged because he wanted to avoid a felony conviction because they had recognized him. Okay. All right. And if the police had just done it, and because they're on their way, and instead of tailing him with two men in a pickup truck carrying guns, just follow him at a distance because he's only going to go so far on foot and wait for the cops to get there. You get an arrest and you don't have a dead person. And it's not a question of sanctioning theft, and it's not a question of tolerating criminality. It's just a question of responding to it in a manner that doesn't, if every situation like this escalates to this point, good luck having legitimate citizens arrest later on, because nobody's gonna put up with it for 30 seconds. It's gonna go straight from 0 to 100.
And for anybody who doesn't understand, there's something called the use of force continuum in law enforcement. And the use of force continuum says it allows officers to, what it does, it gives you simulations of different scenarios. And if an officer, for instance, is arresting someone who's unarmed, you can't then pull out your gun to arrest that person because they're saying that's an unreasonable use of force. And it's a continuum. And what you really want to do is try to stay one level above the person who you're your perpetrator. So if your perpetrator is unarmed, you don't want to go to gun. You may want to go to a soft weapon like a baton or even pepper spray or something like that. So even in this situation, when you do have this person running at you, the use of force in this situation is outside any reasonable use of force that I think could be made, where you're having people confronting an unarmed person with the shotgun. They see the person running, he doesn't seem to be armed, and you're confronting him with a shotgun. The argument that that the person who is being confronted with the shotgun doesn't have the right to defend themselves, but then to make it seem like the person who did the actual homicide shouldn't be held accountable. I'm just not seeing how people aren't connecting the two. I think it's easy to say, yeah, maybe they can be held accountable because this was an unlawful killing, but on the other side, understand that this wasn't that the racial component doesn't have to also be attached to that conclusion. You know what I mean?
Yep. And then it's in Joshua Cornelius. How you doing, Josh? Hope all's doing well. He says the racial component is the only reason why the tragedy garnered the attention needed for Lady Justice to have a look or listen. I mean, I think there's something to be said about that. Chat is saying they weren't pointing their weapons. They're right. Also 69. Well, pointing their weapons, I think, is also somewhat immaterial. Someone approaching you on the street with a gun in their hands, pointing at the ground, the effect is the same when it comes to whether or not you are being unlawfully detained, potentially, or assaulted for that matter. Dapper Dave, difference between these guys and bounty hunters? It's a good question, actually. I mean, I don't. Even bounty hunters follow protocol when they effect an arrest and have secondary weapons to not pull out guns if it's not necessary. Let me just see something here because I want to skip. I don't want to miss these super chats because there's quite a few we got. Okay, Brian Corbino says, thank you very much, Brian. Okay, Voodoo says, just because he could have run in a different direction doesn't mean he legally must. Georgia doesn't have different requirement to retreat like some other states. Now, also from his perspective, is running in another direction more likely to save his life if he believes that he's in under direct threat from individuals carrying guns?
And following him down the street in the truck. He just followed him down the street in the truck.
He made a decision. It led to his death. The only question is, in his mind, if he thinks he's going to get assaulted, is running in the opposite direction going to help you when you're dealing with people in a pickup truck with two guns? And it's not just to explain one way or the other. It's like everybody takes for granted he was getting arrested. In this guy's mind, he doesn't know what the heck is going on and reacted accordingly. If the police were doing their job in patrolling, there would be no need for citizen patrol. Well, maybe. Or maybe the police would have gotten there in 2 minutes, arrested him, and there wouldn't have been no dead person. I mean, we don't know what's going on in that neighborhood. These are things that I wouldn't form an opinion on.
And police are most of the calls. It's rare that you walk up on something. It's the more likelihood that you're going to be called to a call. So
if Travis wasn't chasing with a firearm, then how did he go from the side of the truck to the front of the truck to fight? Self-defense for Aubrey. It's interesting. You're just getting everybody who has one screen, two films, and we're seeing the same thing, and everybody is. My analogy is that when people whistle, it always sounds different to everybody around them, and it sounds different to the person who's whistling, because when you whistle, you hear the music in your head. Everybody's making their conclusions, and they have the music in their head, but everybody's listening to different music when it comes to this. Dapper Day says, trying to understand your logic. The fact he had a criminal possession of a firearm conviction does not play a factor in how he was approached. Not unless they knew.
If they knew it, yeah, you have to show that they knew that he had that conviction. And they don't know anything about the guy.
No, but not only that, if they knew that he had a conviction, then maybe you don't approach him. I mean, maybe when someone's armed and dangerous, everyone's gonna say, vigilante, get your guns and go get him. Or you say, armed and dangerous, hunker down and call the cops. Well, I mean, that's
maybe it's best to just explain what propensity is. In American law, I'm not sure, even in Canadian law, there's a rule against propensity. Just because someone did something in the past doesn't mean they did this thing that we're accusing him of in the present. So even if he had committed burglaries in the past, it wouldn't actually be relevant to this particular act. Did he commit this burglary? Unless you can show that it was he committed those burglaries in such a unique way, like maybe he used pizza sauce on all the locks or something like that. Then you could bring in those facts.
Wet bandits, baby.
Yes.
Yeah.
But otherwise, then yes, you cannot use. So if everybody who keeps saying he had this conviction for this, that would be irrelevant to whether he committed this crime and whether these people had enough evidence to believe that he committed this crime.
Yeah. Well, I'm reading some of the comments. I'm not going to read all of them. But I missed someone's super chat, and I said put it in the comment, but don't put another super chat down. You missed. Dapper Day says you missed my super. I'm doing my best. If bring it in the comment section, I'll get it again. But I missed someone's super chat, and I said put it in the comment. Viva, please. Okay, well, hold on a second. This one says I just missed it. It's going too fast. Viva, please. Did the guys not have conversations with the local police where they were asked to watch out for their thefts on the property by the police? I thought this was, but even still, so they're looking out for theft. But then, you get into Georgia law. Are they allowed making a citizen's arrest? I think we're going in circles because I think we know all the same facts. The only question is now how we are interpreting them. It's the only question of how we're interpreting them, and we're interpreting them based on the music in our heads as to how we're hearing this. Guilty or innocent, the setup. It reminded me of the old movie Deliverance. I'm so for self-defense in this case. Well, we've seen whoever has seen the Deliverance. Okay, if I missed the super chat of whoever I said I was trying to get to it. I'm sorry. Okay, now we should wind this up, but we have to talk about Flynn, I think. 15 minutes on Flynn?
Sure. Yeah.
Michael Flynn, who hold on, sorry. This is it. Midnight says, why are lawyers arguing moral should? This is about legal right. We're all arguing about legal right. Some people are saying they had the legal right to arrest him. Some people are going to say Arbery had the legal right to defend himself. This is like, we are arguing the legal right, but rights are a two-way street. So it's a crazy situation.
Yeah, it's coming down to, did they have the right? And that's what this is going to come down. Did they have the legal right to go and effectuate that arrest? Because that's the only reason why that happened. If they didn't have the legal right, if he didn't commit this felony that everybody's assuming that he committed, then they would not have had the right to commit that, and that would have been an illegal killing.
Yeah, and something else to appreciate, it's not necessarily first-degree murder. It could be reckless endangerment with a firearm, involuntary manslaughter. I mean, it's sort of more like what it looks like. Just because I don't think they went out looking to kill someone. I just think they went out and created a situation where it became increasingly likely that something bad would happen, and unnecessarily so. So how does that go down? We'll see. It will come down to a jury. It'll come down to the evidence. It will. Barnes said something that, if it's true, is going to be very interesting. Is that apparently, if Arbery discharged the weapon when he was shaking it, trying to shake it from his hand, apparently Barnes said by the forensics at the time, it's not even clear that they pulled the trigger.
Well, but hold on. That may walk. See, there's generally a rule too, where if you create the dangerous condition, and you can't then say, he shot himself, because you bring a gun to the party, and we're wrestling, the gun goes off and kills me. Then you can't, then at that time it's kind of that zone of danger thing that you get where you've created the conditions that cause this person's death. So even though you're not the direct cause, but obviously there was no other way that person would have been harmed except for your actions of bringing the gun there.
But that will affect what the conviction might be, what the sentencing might be for the type of incident. Well, I mean, we're going to see. I saw the video. He tried to take the dude's gun. We can even agree with that. If you try to take someone's dude's gun who's pointing at you unlawfully, then what? I mean, we can even agree on that fact. Then it's going to be the precursor and the post-cursor to that. Mandatory carry. Good to see you again. Thank you for coming in, and thank you for fighting.
One good example of this rule is the heart attack in the bank. Like when somebody goes and robs the bank and the guy has a heart attack, and then they charge all the robbers with murder, and they'll say, well, he didn't commit the murder. The guy had a heart attack, but it's kind of like you've put him in a particular situation that caused this death, even though you weren't the direct cause of it. But since you put him in that situation, you murder charge. No,
and that's the other thing in Canada. Pointing a gun at somebody and they jump across the street to run away and get hit by a car and die, you are getting charged. And it's you didn't do it, but you caused the situation because of the probability of what you did. That's something that could happen. Joshua Cornelius says all legal arguments are based on a set of ethics, morals agreed upon by a society. You can't logically separate the two. No, I think the bottom line here is also just facts. I mean, we need to know a little more facts. If we had a full video, it will come out in the wash. Yes. One thing that's going to be clear is that after it comes out in the wash, it's not somebody who got shot for jogging. We can all agree on that. And then we're all going to disagree on whether or not it's justified, whether or not it's acceptable, whether or not it's predictable based on the set of circumstances, and then whether or not it's culpable in law. It's going to be all right. All right, so let's do it very quickly because I don't think we have much to talk about. Does anybody not think that Michael Flynn got the proverbial by government?
I'm on two sides of this coin. On one side, he lied to the FBI, he lied to the VP. Everybody knows that he lied, and he was convicted, and he told the court, "I lied." So now. That piece of him actually being criminally liable, I think it's, it is what it is. But then the piece of it of how we got there, I think that's the piece that's the problem. Because if he didn't, if the FBI came to the conclusion that there was no crime, then why have that interview to have him then commit a crime? You know what I'm saying? That piece I do think is an issue.
So that's the one thing. Someone says jury nullification for Arbery is a real issue. We may have to talk about jury nullification on a separate stream because it's an interesting question. With Flynn and Nate, this is where I feel like I stepped into the Matrix with Michael Flynn because I said the same thing. He lied. He admitted he lied. Trump said he lied. That's why I fired him for he lied. Okay, fine. So it was incidental, but he lied. Reading through the motion drafted by the Department of Justice or the government, his lie, I wouldn't call that a lie under ordinary circumstances. I would call that like I did. I would qualify that like they did as an equivocal answer. I'm not sure. I don't remember. And you have the transcripts anyhow. So why are you asking me? Type thing. I wouldn't even qualify what he pleaded guilty to as a lie, knowing what I know now. And I have no vested interest in this. I was on the other side of the fence at in the early stages. I said Flynn lied. He admitted it. End of story. His lie, I wouldn't qualify that as a lie, even if I thought it were untrue. And knowing the context, how they got him into that room, when the investigation, and for anybody who doesn't know, the investigation should have been closed. They announced that they found nothing on him after 4 months. Yeah. So we're going to close the investigation, but because of, as Peter, and I'm calling him Stroke, I don't care if his name is Stroke, for a number of reasons. The Stroke, but for their incompetence, hadn't closed the investigation, so they got him to get down to another sit-down meeting, where, as a result of their leaked notes, it became clear that their goal might not have been to get the truth, but might have been to get a lie for the purposes of firing or prosecution. And they got it. But it's terrifying. And the other thing is, like, most people don't appreciate, they didn't sit him down in a formal investigation to notify him. It was like, hey, we want to talk to you about this conversation you had with Kislyak. And he's like, oh, you have the transcript. You know what I talked about? Yeah, we just want to get some details. And then they got. How is that not entrapment? Someone's got to tell me what entrapment is.
But hold on. Anybody who's gone through an FBI background interview should know, if you what's the phrase? If you lie, you die. Right? If you lie, you die. you lie to the FBI, you're in trouble. Matter of fact, they'll usually prep you and say, don't answer, just it's rather not answer the question than lie to the FBI. Especially something they can prove. So, and I think Flynn would know this. Don't get me wrong. I think Flynn should have never been in the position to give that answer, to be found to be lying. But I think people also have to rap with the reality. To say he didn't lie, you're talking about a federal judge got it wrong. You're talking about those career prosecutors got it wrong. You're talking about a lot of people who've been doing this a long time. All of a sudden, for this one case, got it so horribly wrong. It just I don't know. I think politically, I think Flynn's a good case for to get out of there, because I don't think the president should leave anybody on the field. But the fact of the reality is, he did say what he said.
Well, but even what he said was not a lie. It was like sort of, I don't know, I'm not sure. And I don't think a judge got it wrong. I don't think the prosecutors got it wrong. I think the prosecutors knew what they were doing. They basically, I don't want to say extorted, but they pressured him into pleading guilty to avoid further consequences, investigation of his son, bankruptcy. So it's sort of like pleading guilty under duress to avoid what he knows the FBI is going to do if he doesn't plead guilty. And and someone was telling me he pleaded guilty to avoid charges under the Logan Act or whatever, or other prosecution. I said, no, if the FBI thought that they had charges under that, they would have never accepted his stupid pleading guilty to some insignificant lie. They would have gone straight after him for all the other stuff.
Oh no, that's what you do. That's what you do. You get them, you get them on. That happens. When I was a prosecutor, you could do that all the time. You threaten a charge with a whole bunch of stuff, and you settle for something small. It's just the nature of the beast.
You're not going to make people like the cops or the FBI anymore from that.
No, but that's how you get a deal. You say you want to. We can hit you with these 40 charges, or you plead to this one, and we call it a day, and that's generally how it goes.
In the mob, they call that extortion. It's. All right, Joshua Cornelius says, hey, Nate, should everyone who lies to the FBI be charged? Does the fact that he was set up not factor into your thinking?
Yes, and then that's what I said. The way you got to that interview, which he lied to the FBI, I would say is problematic. I would say, okay, he shouldn't have even been in that position to lie to the FBI. But the fact of the matter is, he did lie to the FBI. He knew lying to the FBI was a criminal act. And then he went and lied to the vice president, and you got a federal judge and career prosecutors who also went through it. So that's where I'm just going to, yes, the way we got there is wrong, but he actually did break the law.
And Dapper Day said if they had an open criminal investigation when they interviewed him, they aren't required to advise him of his Miranda rights and take a sworn statement.
No, Miranda only applies if it's custodial interrogation. So if the police are asking you questions and you're free to leave, then they don't have to give you Miranda. So no, because the FBI came up to him and started a casual conversation with him or whatever, but he could have told him to blow off or walk away or anything else. So Miranda, no.
Now, is that true? Because for instance, I'm not sure how it is with federal employees, but in some instances, if we're asking you about your job as a federal employee, you don't have those same protections. Like you can't tell me to go F off, that type of thing.
Well, there's Weingarten rights and stuff for federal employees for disciplinary actions. There's stuff with the inspector general, but they can require you to give a statement. But I'm pretty sure the Fifth Amendment still applies. But if it's custodial interrogation, then they have to.
Yeah, but he wasn't been under arrest. I'm just trying to see, could he have had an attorney there?
Apparently they talked him out of having the White House canceled, because they said, if you want to have the White House canceled, we might have to bump this up to the Department of Justice. I'm not exactly sure what that means.
It probably should have been, because my understanding is procedurally, it should have been coordinated through the Department of Justice because of the nature of the political position. It should have been coordinated in the first instance through DOJ. It should have been coordinated through White House counsel in the first instance. So saying, if you don't cooperate, we'll have to bump it up to DOJ. That's not a threat. That's just like what you're supposed to do.
Yeah, they were cutting corners. But sometimes it's easy to do that just if you want to really get the interview, though. So
Scott Burton says, if they threaten to put your child in prison if you don't confess, what do you do? Oh, you confess. There's no question, especially if you confess thinking that you're not going to do jail time, and then you end up in front of a federal judge who says they might sentence you under treason, and are they not going to be bound by the plea bargain? I mean, then you might start rethinking your. I will slightly disagree, and
this is intended to be more of a slight disagreement. But I'm not. It's not clear to me that he lied to the FBI. It's not clear that lie was material within the meaning of the statutes, and so I think that that is a little unclear. I think that they were trying to use that as it's their favorite charge in the whole world, lying to a federal official. 18 USC 1001. They're like their favorite thing in the whole world. So they always throw it at everyone because it's pretty hard to make a statement and not make some mistake along the way. It's like, oh, you lied, you knew better. It's like, give me a break. Jeez.
No, especially when they go ahead and modify their investigation notes. I mean, it's impossible not to lie to the FBI, which brings us to Ozian. Note to self, never talk to anyone who works for the FBI.
Yeah, you don't want to talk to anyone who works with the FBI without attorney present and preferably being prepped in advance. And probably just don't do it would be a good advice. Just don't talk to the FBI. They love that charge. The line to the federal officials is their favorite thing in the whole world because it's so easy to trip up. So easy. So
Not Here says, can you type in this link? Thanks, fam. Also 60. Jeez. Okay, I imagine this is the Georgia statute that probably relates to 417, 460, maybe burglary.
That sounds like the one for citizen's arrest, isn't it?
Title 17, Chapter 4, Article. Whichever, it's there if anybody wants to go put. I can't put it in because first I wouldn't do it anyhow.
Yeah, I got it.
Lord knows what happens if I put that in. Isaac Wick says, this just in. When an unarmed black man is shot, well, do you really think the police got it wrong?
What?
I'm not sure I understand. I mean, I think I understand the point. I think the bottom line is, if this, I think the bottom line with the Arbor cases, even if they were uniformed officers, if they come out with guns drawn, I mean, it would still be a question of excessive use of force by the police. The fact that then you'd have the argument that he charged them. I don't think he charges if they're police, but I think if police come out guns drawn for a guy walking, in loafers on the street, even if it's suspected burglary, you might still have the same arguments. I mean, you
can't just gun people down.
And where Flynn got really bizarre was not even with the dismissal, but the judge apparently deciding, I want to hear from amici.
Oh God!
In the middle of a criminal trial. Oh no, you didn't hear about this?
No, Nate heard
no.
it. Go, get it, Kurt.
Oh yeah, no. The DOJ moves to dismiss, and the judge says, well, rather than do that, what I'd like to do is I'd like to hear from amici curiae to argue against this at the trial stage.
And who is the lawyer? Kurt, who's the lawyer? The retired judge.
It was a retired judge that they appointed. Yeah, who is not exactly the biggest Trump fan in the history of time. So yeah,
the judge self-appointed a friend of the court to oppose the Department of Justice and Flynn's mutual, consent to drop the charges. And he brings in some guy who's been, writing op-eds or tweets or whatever of how Trump has been interfering with justice or perverting justice.
I have never heard of an amici in the middle of a criminal trial.
Well, hold on.
Ever.
This doesn't make well. Isn't Flynn is being sentenced though, right? So he's already been convicted, all this other stuff, and now they're trying to undo the guilty verdict.
Convicted on a guilty plea, not on a guilty verdict. Yeah, so but that changes something in law.
Well, at the end of the day, not really, because he's still guilty. Yeah, he's still guilty
until the sentence is imposed. It's not final, so it can be withdrawn.
I don't know.
Well,
I don't know about that. That's
apparently the outrage is bipartisan because nobody can believe what the judge did, and apparently it violates a precedent from the Supreme Court that's barely a week old, or maybe
that too.
9-0, which says you don't go out looking for. What is it? The Don Quixote type. Like you're looking for people to slay dragons that nobody invited into the courtroom. It's crazy. It's crazy, it's basically the judge is self-shopping for a prosecutor in the case now. It makes no sense.
This is kind of crazy. Yeah, this is crazy.
Is the most bizarre. This judge. I can't believe what's happening. I can't believe it before my eyes. How biased do you have to be? It's like, well, I already got my motion to. I got my motion to make you recuse. Well, so obviously pretty biased.
Yeah, I'm just trying to figure out because I just don't know at what stage, because the court can sometimes make its own motions for certain things. A lot of people don't realize that the court. I went to see why the court make its own motion, or but then you can't be the arbiter. I don't know. It's a strange little situation.
Oh no, it's strange. It's objectively strange. Everyone is up in arms left and right, except for the media. Because everybody thinks they'll tolerate an injustice if they hate the person enough, which is doesn't make sense. So Killsey says he didn't lie. They never asked about him. They never asked him about sanctions according to 302. They asked about expulsion of 35 Russian, not sanctions. They were conflated. I won't disagree with you. I don't think he lied. I haven't read the transcript of his answers. I read his answers as depicted in the motion to drop the charges. I wouldn't call it a lie. I wouldn't
I would say this just so people understand. When you get a criminal conviction, the judge has to make sure that these facts are enough to hold you criminally liable, right? So, was there a lie? Was this lie material? And was this, and go through all that process. So the judge, the prosecutors, the defense attorneys, and they lied for specific things. Like this is specifically what happened. So it's hard for me to say that they went through all that process and he didn't lie, because then you're saying there's a lot of people, this judge in particular, and all these prosecutors who don't know how to get this. You know what I'm saying? It's not like this is a complicated charge. It's something that's very simple and something that's done all the time. So it just seems unlikely that it wouldn't be enough for conviction, because it just doesn't seem like it is.
Well, the motion from the, and also to preface this, a lot of people might just say that the motion to drop the charges is itself political because it's drafted by a political appointee that Attorney General Barr appointed. He's a Trump man, and it's all Trump getting involved in the judicial system to have charges dropped against his friend. That's going to be the argument. No comment. I don't agree with it, but that's the argument. But even according to the motion, they said it was equivocal, which is what I'm Nobody's basically saying. It says I'm not sure. And even if it were a lie, it was totally immaterial to anything because they had the transcript to know exactly what he said. Therefore, lying about his recollection is totally immaterial to what actually happened. And to anybody else saying he violated the Logan Act, if he violated the Logan Act, they had the transcript to charge him for that specific crime, notwithstanding his recollection of what he said he remembers having said when they had the transcript. So it's, in my mind, it's like it's black and white corruption. I don't know if you call it entrapment or what's the word I'm looking for? Deceit, whatever. But man, I wouldn't call it a lie in the best of circumstances. It's not like, I did not have sexual relations with that woman, or it's not like there was nothing classified on that email server. It was an equivocal statement and not an unequivocal one. We got Jason Fritz, a new member. Jason, welcome to the family. Booyah. Okay, let's see what it says. The lie, if there was one, was not material, then it's not criminal. Goyo, go. You were at me. Okay, I think we've done it. I mean, no, the Flynn thing is crazy because it is literally why everybody in there, jokes around. Don't talk to the police. Don't talk to the FBI because and it's what Barr said. It's like Michael Flynn. Maybe I'm wrong. Maybe I don't know. An unscathed, untouched, impeccable record of 35 plus years as a military person serving the country. Never a problem until it gets involved with the Trump administration. And then after 4 months or whatever, a year of investigation, the only thing that he's brought down on is being tricked into providing an equivocal statement that is spun as a lie based on handwritten notes of FBI agents that subsequently disappear, based on text messages where they're admitting they want to entrap him for the purposes of getting him fired or prosecuted. It's not even Kafkaesque. It's oddly enough, it's like Russian level corruption. Let's see. We got Matthew Chris says Flynn's law firm at the time was leftist and was working against his interests, not malpractice, intentional harm of Flynn. Barnes touched on this also. This is something I can't get into because I don't know the details. I don't know the nuances. Apparently, the firm was partners with other players who were on the exact opposite end of the spectrum with diverging interests. And the question is, how the hell is it his own law firm that discloses this information after he pleaded guilty already? Like, there's malpractice issues in there or ethical issues, but it was his own law firm that disclosed the handwritten notes, and not the. I forget. I don't want to actually I don't want to be accused of misrepresenting. My understanding is that this information was already in the hands of his own attorneys. And they found it on a subsequent search.
Well, I know for us in New York, let's say, for instance, as a prosecutor, if I'm having an interview with the perpetrator and I take any notes, those notes are now discoverable material. So I have to turn those notes over to the defense so they can see what I wrote down. So I'm not sure if they have the similar thing in the federal circuit, but it seems like they may have had some similar thing where they took notes and they turned over those notes to the defense, and they just never went through those notes.
Well, and that's what that's what Barnes might explained it like. He said, like you digitize them, you get OCR recognition, optical character recognition, so you can search for words, and they did a subsequent search afterwards. I don't know what happened, what changed. From what I understand, it wasn't actually newly disclosed by the FBI. It was newly discovered by Flynn's counsel, which raises a bunch of other questions. But crazy. Here we go. Covington and Burlington withheld 6,000 documents from Flynn. It's never a good thing when your own counsel withholds documents from you. Covington and Burlington, I think, is the law firm that was representing him. Okay, let's see this here. We got Dapper Day says, constantly talk about separation of powers. If Attorney General who is a DOJ employee has to testify to the Senate, Congress, why can't a judge of a Department of Justice employee? Okay, I'm not sure what you mean, but I think, well, it depends. A judge. I mean, if I'm understanding the question,
like it,
judges, you don't get judges to testify because you don't get judges to testify ever. Employees would be different, but certain actors have immunity that others don't, and others.
I've certainly seen judges in Congress.
Yeah, they testify for their
stuff. So
for their budgets. They have to testify for their budgets. Yeah. So what's his name? Thomas loves doing it.
Okay. Scott Burton says original 302s vanished. Agents had to recreate them. Oh, it's crazy. What's crazy? The only thing that's really crazy to me is that the outrage is not unequivocal on both sides. People now saying, the FBI does it all the time. That's how they do things. If that's true, that's a big, big, big problem. That's a big problem. That's why nobody trusts law enforcement.
You know what? You probably I think you guys are probably right, because I don't know. Maybe it's because I have been on the other side of that table. I've been on the other side trying to get a confession, trying to do this, trying to do that, and things. We're not perfect people. Things fall through the cracks, but it just is what it is sometimes.
Well, but it's also different than with Felicity Huffman, and they press charges and then they plead guilty or they don't, and if they don't plead guilty, they supersede the indictment.
Yeah,
that's one thing, and that's at least on paper and pen. In Flynn's case, it seems that the threats to prosecute his son were unwritten but clearly implied, and it seems the intent to convict, notwithstanding the truth, was pretty clearly on paper but never disclosed, and then subsequently disclosed. But
don't get me wrong. I think threatening people's families, I think, is a little much. But the thing is that and I hate to expose you guys to it, but it happens when if you could say, well, your son, like here in New York, we had the congressperson to get him. But his son was just as corrupt, stealing money from the not-for-profit, all this other stuff. So they said, we're going to prosecute you both. But guess what? He gave up his seat, and that was all she wrote. So sometimes if you have this, in the mob is another place where they do this too. So I do understand what it may look like on the outside. But if they had facts to support that this person was committing a crime, then we're going to put him in jail because he's committing crimes. Or you make a deal so we don't have to spare the expense of a trial.
Well, I think that's the particular problem with Flynn, is that now it's become clear they knew they had nothing, but that by fortuitous events, they could still schedule this next meeting where they would get him. And they did.
Yeah.
So I'm nobody says, I'm pretty sure the notes taken during a meeting are protected by, no question. A solicitor client notes are privileged. The question is more, the investigators investigating's notes are discoverable. So
No, well, again, it all depends on what state you are, because as a prosecutor, when I'm taking notes in an interview with the defendant, those notes are discoverable materials. The defense attorney gets to see my notes. That's why they usually train prosecutors to just to not take notes, so you don't have to turn them over. But yeah, those are discoverable. I forget, they're not Brady material, because Brady material is something different. I forget there's a particular name of the case that we use for those, and I just can't think of it on the top of my head. But yeah,
we got our Strokes Act's criminal. I depends on who you ask. I would think they certainly are getting close. Will they be prosecuted? Probably never.
No.
As a Canadian viewing this, it seems that prosecution is a one-way street, a political one-way street in the States.
They feel suspiciously criminal. It's like purposely set this guy up for political reasons, bad motivations, bad intent. Yes, I think FBI agents are committing crimes. I'm going to go with yes.
All right,
prosecute him.
And on that, I think we're going to wind this down. I'm going to try to end this at exactly 2 hours on the nose. So we're going to thank everybody for coming. Uncivil Law, Nate Broady, thank you very much. This is always fun. This has been a nice quasi-marathon of a
no
stream.
Controversy.
No controversy.
Right. Nate, Kurt, you're going to go watch. I think Kurt, you're going to get it on the Arbery, on your opinion on the Arbery.
That's all right. They can keep coming at me. That's fine.
I can at least I can always qualify my opinion as I'm a totally different cultural individual coming from Canada. All of this is the idea of approaching someone on the streets with weapons for a citizen's arrest is foreign to me. It's foreign to me, and for right or for wrong, it just it doesn't ever go anywhere good. For non-violent, non-urgent things, I call the cops. Urgent is a different matter. But and with Flynn, man, Flynn is an eye-opening experience. This whole thing since 2016 has been utterly eye-opening. I mean, it's a different world. Gentlemen, okay, stick around. I'm gonna say goodnight. We'll say our proper good nights after this, and I'm gonna go hit the end broadcast. We're gonna get it at exactly 2 hours tonight. We're gonna end the broadcast